Law Brain YouTube channel. Nowadays we hear a lot of news where the patients as well as the patient relatives complain about the doctors as well as the hospital for the alleged wrong service given to them. Because of this, the doctors as well as the hospitals are getting blamed, and this is affecting their professional career. In USA, many doctors, especially OG doctors, after 50 years do not practice to avoid such complaints. And today, we have an expert with us who deals with medical legal cases, consumer cases in all the consumer courts all over India. And he has written a lot of books regarding this field. Hello, sir. It's a pleasure having you, sir.
Thank you.
He is advocate Mr. Samuel Abraham, who is a consultant to many institutions, and he has been in this field for more than 30 years. And it's a pleasure to have him here. And on behalf of you, I put forward some questions to him.
Sir, in the new Consumer Protection Act made in 2019, did they delete the medical practice or is it still included, sir?
This is a very good question actually. Many of the doctors are not clear in mind. Some doctors think that it has been deleted in the new act. When the old act in 1976, that part also it was not included. But it was included subsequently by the Honorable Supreme Court of India in a judgment called V.P. Shanda versus Indian Medical Association of India case, where the Supreme Court has held that whenever there is a contractual obligation between two parties, it comes under the Consumer Protection Act. Once upon a time, the medical service was considered as a gratuitous service. That means without receiving any consideration. The moment the patient is paying professional fee to a doctor and hospital, and for that in return the hospital and doctors are giving medical service to the patient, it becomes a contract. Normally, in the contractual obligation, if there is a person who is receiving the service, he becomes a consumer. And it is not the parliament or any legislature which brought the medical service under the protection of, under the purview of Consumer Protection Act. It is the Supreme Court of India which brought this service under the Consumer Protection Act. Now in 2019 Act also, it is not deleted, it is being continuing, and even today complaints are filed before the Consumer Protection Fora or Protection Court, consumer courts in all levels, and we are attending the case now. So in case the Honorable Supreme Court of India in a larger bench overrules the present case, V.P. Shanda versus Indian Medical Association. She has filed a complaint that there is a negligence and deficiency of service on the hospital which gave treatment to her husband. So she was the party petitioner before the High Court, and the Indian Medical Association went to the Supreme Court to get some relief for them, but the Supreme Court refused, and they included medical services under the purview of Consumer Protection Act. So after 1996, all the services given by the medical services considered to be a contract. So a patient comes to the hospital on contractual obligation and he pays for that, and the hospital is expected to give a standard care to the patient. Now subsequently in 2019, the Parliament brought new Consumer Protection Act. They have neither included nor deleted.
Okay.
But however, the same thing will continue till the Honorable Supreme Court repeals or reconsiders this judgment.
Okay.
Sometimes more judges in the Supreme Court in a particular case may overrule this judgment. Till then, it will prevail. So as on date, the services offered by the doctors and the hospital to a patient becomes a contract. Thereby, they will continue.
Okay. Thank you so much, sir.